We'll go ahead and call the this hearing to order, and I want to thank all of our witnesses for appearing here today. Some of you come a long ways, and we appreciate that very much. The purpose of today's hearing is to examine the proposed rules and case decisions by the National Labor Relations Board and the Department of Labor related to employer and employee rights in union organizing drives. This committee has kept a particular focus on federal regulations and policies that are adding to the array of uncertainties confronting small businesses, particularly when those uncertainties add to the nation's stubbornly high unemployment rate. Republicans and Democrats agree on the principle that businesses need certainty if they're going to grow their businesses and add jobs. President Obama has widely touted an executive order directing government agencies to identify and cut the red tape that's out there. He's also ordered agencies to do more than the bare minimum required to ensure that stakeholders have an opportunity to communicate their views on agency regulatory actions. If this is the intent of the President's executive order, it has been put into practice. Rather, the NLRB and the Department of Labor proposed the imposition of new regulations despite the lack of any demonstrated need for changes to existing law and practice. The current NLRB board has been particularly activist in its agenda. There's the infamous NLRB decision to prohibit Boeing from opening a plant in the state of South Carolina. And while this decision does not directly impact small businesses, many of those in the small business community are claiming such decisions are indicative of the NLRB's overall bias against employers and the level of favoritism it's granted to unions. Today's hearing is going to focus on 4 examples of this administration's union favoritism: the NLRB's decision in the Layman's Gasket Company and Specialty Hospital of Mobile, the NLRB's proposed changes to the union election process, and the proposed rule from the Department of Labor regarding the advice exemption to the Labor Management Reporting and Disclosure Act. I'd also be remiss if I didn't mention the NLRB's final rule requiring employers to post notices in their businesses informing employees of their right to unionize. I understand this has been particularly irksome to small businesses who object to what they view as an unwarranted federal intrusion into their business, as well as their objection to the biased nature of the notices themselves. Again, I want to thank you all for being here, and I'll turn to Ranking Member Velasquez for her opening statement.